So I hope everyone had a good lunch, and we're ready to continue and listen first to the claimants. And you have an hour if you wish to use up an hour.
Thank you, Madam President. The order is going to be as follows from us. First, I'll address the question regarding footnote 621 in the claimant's memorial. Then I'll address the questions as regards the content of the FET standard under the BIT. Then Dr. Veit will address the questions that related largely to valuation date. And then there is another matter regarding the prospecting license that Mr. Barrier will address. But to start on the question of footnote 621, we thank the tribunal for drawing this to our attention. We did indeed reserve the right to make a separate claim based on the full protection and security standard. However, the claimant decided in its reply not to pursue that claim and confirms that it doesn't intend to do so in these proceedings. And the reason for that is that it's clear to us that this case is one of expropriation and fair and equitable treatment. Now, moving to the question regarding Article 6.1 and 2 of the BIT and the guarantee regarding minimum standards of treatment in accordance with international law, including FET, and your question as to whether that provides for a protection of legitimate expectations. So, yes, it is our position that customary international law minimum standard of treatment does include the protection of legitimate expectations. And the reasons for that I'll give to you over the next few moments. So if we look at Article 6, it obviously has two subcomponents. Section 1, in which it says, each party shall accord to covered investments treatment in accordance with customary international law minimum standard of treatment of aliens, including fair and equitable treatment and full protection and security. And then in Section 2, it says, of course, the concepts of fair and equitable treatment and full protection and security in paragraph 1 do not require treatment in addition to or beyond that which is required by the customary international law minimum standard of treatment of aliens. Now, like many investment treaties, the BIT does not provide a definition of what constitutes FET, except for the fact that this notion should be understood in respect of the customary, in accordance rather, with the customary international law minimum standard. So it must then be interpreted pursuant to Article 31 of the Vienna Convention on the Law of Treaties, in accordance with the ordinary meaning of these terms, its context, and the object and purpose of the treaty. Now, in accordance with Article 31, the use of the terms FET, instead of using only, for instance, the expression minimum standard, means that the contracting parties intended to give the FET standard an autonomous meaning. This means that the distinctive features of the FET standard thus included in the customary international law standard of MST. Otherwise, it's our position that there would be no other reason to include reference to FET. It simply could just say MST. In any event, you'll be well familiar with the fact that the CMS Tribunal concluded that, quote, in fact, the treaty standard of fair and equitable treatment and its connection with the required stability and predictability of the business environment, founded on solemn legal and contractual commitments, is not different from the international law minimum standard and its evolution under customary law. And of course, that can be found at Exhibit CL19, paragraph 82, and the paragraphs that follow. But I want to focus on that word evolution. And it's important for reasons that I'll come to in a moment. But in the meantime, it's important to note here that the parties share the interpretation of Article 6.1 of the BIT, namely that the MST and FET should be treated as the same standard and that FET is interpreted with the boundaries of MST, including the concept of legitimate expectations. It's firmly established in arbitral jurisprudence that FET standard can encompass fundamental elements such as legitimate expectations. Now, in particular, the Echo Oro Tribunal considered the FET standard as part of the MST, encompassing legitimate expectations, and provides investors with the protection of a stable and transparent investment environment as well as good faith. Now, I want to explain that a bit. As I said, the Echo Oro decision from 2021 it explains in great detail that the MST standard, in the context of a BIT that's quite similar to this one, in that it says the FET standard in accordance with MST. Now, ultimately, Echo Oro concluded that this FET, as defined by MST, does include legitimate expectations component. Importantly, it did so after concluding that the MST standard must be considered to have evolved with time. So in that evolution, legitimate expectations became part of the standard. But in coming to that conclusion, the Echo Oro Tribunal undertook a very helpful analysis of the overall content of this evolved MST standard. Now, starting with the premise that a state can change its laws and its regulatory environment, but it must do so in a way consistent with requirements of customary international law. Now, I should note that this discussion starts at paragraph 743 of the decision, and that decision is Claimants Legal Authority 125. So, in that sort of discussion of how the MST standard has evolved, the tribunal starts with the premise that a state can change its laws and regulatory framework, but it must do so in a way that is consistent with requirements of customary international law and FET, and it's block quoting there from the NAFTA decision, Mobile Investments. So if we look at decisions that are captured within the analysis, like Waste Management, Saluca, and Teco Holdings versus Guatemala, obviously the FET standard includes protecting legitimate expectations, refraining from arbitrary or discriminatory treatment, or unjust or idiosyncratic actions. But then, looking at this evolved MST standard, the tribunal goes a bit further, and it says that there must be some, quote, aggravating factor such that the acts identified comprise more than a minor denigration from what is internationally acceptable. There must be shock, there must be outrage, or gross unfairness. Now, Echo Oro also looked at a much-cited expert report by Professor Schroer, which sets out certain indicia of arbitrariness or those aggravating factors that the tribunal discussed. And I'm going to enumerate those indicia. First, point A, it's a measure that inflicts damage on the investor without serving any apparent legitimate purpose. B, a measure that isn't based on legal standards, but discretion, prejudice, or personal preference. C, a measure taken for reasons that are different from those put forward by the decision maker. And D, a measure taken in willful disregard of due process. Now, of course, it's necessary to consider all of the facts and the circumstances when you are assessing whether indicia like this have been met. Now, notably, we say, and Dr. Veit will elaborate on, that this includes the saber rattling that President Magufuli started in late 2016, and it also includes measures that transpired between January 2018, and the tender itself in 2019. Now, whether you agree with Echo Oro's conclusion that legitimate expectations is part of MST, we would say is actually immaterial. And that's because under any of the analytical guidance that's set out in Echo Oro's handy analysis of the content of the standard, there's been a breach of the FET or the evolved MST standard here. And let's just look at some of the facts by reference to Professor Schroyer's indicia. First, a measure that inflicts damage on the investor without serving any legitimate purpose. Well, we heard Professor Nrumah yesterday, who was at one point the chief executive officer of the Geological Survey of Tanzania, and who sat on the Mining Commission at the time that the measures took place, say that he didn't know what the purpose of the repeal of the retention license was. And we know that none, not a single one, of the policy papers or the various committees that Tanzania promulgated in the lead up to the 2017 changes discussed the retention license category or what impact it might be having on the sector at large. Now, Part B, a measure that's not based on legal standards but on discretion, prejudice, or personal preference. Well, only one out of eight only one out of eight of the retention license holders affected in 2017 was Tanzanian, a company called Precious Metals Limited. Now, I have no idea of what that company is actually pursuing. Can't even find a website for it. And as far as we can tell, they actually settled with the government straight away in what appears to be some form of sweetheart deal. But our friends have adduced no evidence to that end. It's another one of these sort of black boxes. So the defense that there has been no discrimination here when 7 out of 8 license holders were foreign has not been substantiated. Moreover, President Magufuli is on record with the likes of CNBC Africa and Reuters, not exactly irreputable press outlets, as demonizing foreign investors and foreign mining companies because they are, well, foreign. Moving to C, a measure taken for reasons other than those put forward. Well, no reasons were put forward in 2017 by the government of Tanzania as to why it withdrew or rescinded or repealed the 2017 the retention license category in 2017. Now, we heard this week from Mr. Agenje that they just wanted to move the projects forward. Well, not a single one of those mines is in production today. Not one. In fact, 3 of the 8 are subject to treaty arbitrations. In all likelihood, the retention licenses were probably canceled so that Tanzania could have one more piece of leverage in its fight with Barrick, given that Barrick held a JV over the Kabanga nickel project. So, and that's not one of the reasons that's been given. Now, D, a measure taken for reasons that are, D, a measure taken in willful disregard of due process and proper procedure. Well, our friends, under the guidance of Professor Kabuti, who was the head of the negotiating team with Barrick during their dispute, inserted the repeal of sections 37 and 38 into the draft bills the day after the consultation process took place. So no one in Tanzania, including the Tanzanian Chamber of Mines, let alone any retention holders, had the ability to provide any meaningful content on that particular part of the measure. What's more is that our friends in Tanzania have had the gall to tell us that the tender that took place in 2019 was illegal. They're admitting that this process didn't take place pursuant to due process. So our position is yes, FET does contain legitimate expectations, and those legitimate expectations were not realized or frustrated. And that the FET standard must be read as simpatico with the evolved MST standard. But any way you give that amalgamated standard content, that content here has been breached. Now, the last thing I want to say here is there's also a backstop. And that backstop is that Article 5 of the BIT provides that each contracting party shall accord to investors of the other party and their investment treatment no less favorable than it accords in like circumstances to other investors and their investments. It's got an MFN clause. So thus, even assuming that the reference contained in Article 6.1 of the BIT somehow placed some form of restriction on the FET standard, and indeed its inclusion of legitimate expectations, the claimant's going to be entitled to an unrestrained, full-blown FET treatment accorded by Tanzania to other investors. So you can take a look, for instance, at the Swiss Tanzania BIT, which is at Exhibit CL27, which also contains a standalone FET standard. Or, alternatively, the Mauritius Tanzania BIT at Exhibit CL28, which again includes a standalone FET section. And with that, Madam President, we'll move on to some comments by Dr. Veit.
Thank you. Now, what happens to the 2017 and 29 steps or occurrences if the tribunals considers 2018 to be the actual valuation date? I think the nature of the respondent's obligation under Article 10.2 of the BIT is that it could be breached by one act or by a series of acts. Now, an illegal expropriation could in theory have happened in one measure or by a series of measures, as you know. The claimant's case is that it happened by a way of a series of measures. Under the ILC draft articles on state responsibility, Article 15 makes clear that where a state breaches an international obligation by way of a composite act, the breach occurs when the act which is sufficient to constitute the breach takes place first. You have that in Exhibit CL72, page 62. So therefore, to the tribunal's question, what happens to the 2017 and 2019 steps if the tribunal thinks the 2018 date is the date of expropriation? Well, given the expropriation was a composite breach, as a matter of international law, the breach began with the first act in the series, the amending legislation, as we say. So the 2017 amending legislation would constitute the beginning of the illegal act because that removed the legislative basis for the retention license in Tanzania. That had an impact on existing licenses because it removed the rights conferred under those licenses that were contained within Section 37 and 38 of the Mining Act that were repealed by the amending legislation. To give an example, and an important one, Section 38.2 of the Mining Act gave a retention license holder an express right in the law to apply for a special mining license, as if it were a holder of a prospecting license. Without these provisions in the Mining Act, the claimant no longer had that right. But the other general measures included in the amending legislation were also of an expropriatory nature, even though they did not target the claimant's retention license specifically. And I would like to draw your attention to a slide from our opening statement. These are the measures I'm talking about. Now, you see on the slide the measures. First, the introduction of a 16%. It's slide 105 for the record. 104, sorry, for the record. The introduction of a free carried interest is simply a partial expropriation of any future project, including what would have become of the SMP project, but for the full expropriation. As we found out this week, this was not going to be the end of it, unfortunately. You have also seen that the invitation to tender that we have discussed quite a bit provided that Stamico would get a 20 to 30% additional interest in the joint venture on top of the 16% free carried interest. We also know from the amending legislation that the state could push its participation up to 50% of all mining projects by contributing in the form of tax deductions. We also heard from Professor Mruma that the special presidential negotiation team is negotiating higher stakes for Stamico in the joint venture operating companies. So in short, the 16% were just the beginning. The increase in royalty rates and the introduction of clearance and inspection fees were also harmful measures. Such increase impacts significantly the future returns of the projects and affects the profitability going forward. The impossibility to meet local content requirements increased the logistical and financial burden on mining companies, including the project. Finally, the obligation to submit the project's core and geological data is another harmful measure. As explained during our opening, the core and geological data constitutes proprietary data which may have substantial value to a third party that is taking over the project. Now, none of these measures taken individually would rise to the substantial deprivation threshold of an expropriation. However, taken together, they would have affected the value of the project to a point that it would have been unable to attract any further financing. To be clear, it is our view that the 2017 provision, including the ones I just named, and the repeal of sections 37 and 38, were part of the first step in the Composite treaty breach. But those actions should also be considered in assessing the FET claim, as they were arbitrary in the way just described by Mr. Foden and harmed the claimant's investment. So, the 2017 amending legislation was the first step in the removal of the claimant's rights under its retention licenses. Then, as we know, the retention licenses themselves were cancelled and reverted to the government on 10 January 2018. Of course, if the tribunal considers that to be the date of expropriation, then the breach would be complete at that stage. It would follow that the 2019 tender would not impact the expropriation claim in that alternative scenario. But we would still argue that the respondent breached its obligation under Article 6.1 of the BIT by its actions beyond that date. The government acted arbitrarily and utterly opaquely towards Helio from January 2018 to December 2019. Its conduct fell squarely within any definition of fair and equitable treatment, including the within meaning of Article 6.1 of the BIT. And what would be the impact on damages in that scenario? Well, Ms. Wall set out her calculations for the alternative valuation date of 10 January 2018, and the claimant would be claiming that alternative valuation plus pre-award interest, which would be greater, obviously, than the alternative scenario because it would run for longer. Now, in addressing Judge Johnson's question on the expropriation claim, where he essentially asked us explain how, if at all, we take into account events that happened before the date that would have an effect on the value of the asset on the expropriation date. So he asked, are we to look at the valuation in 2017 and somehow ignore what happened before 2017 or before 2018, and if not, why not? Now, let's deal with that question? Well, if I could refer back to my previous explanation on the nature of the breach of Article 10, our case is that the breach was a composite act, whether you take 2018 or 19 as the valuation date. So it started in 2017 with the July 2017 legislation, and it continued all the way through until 2019, or the alternative scenario 2018. That means if the value of the asset was lowered because of the start of the breach, in this case the 2017 legislation, then the effects must be excluded from the valuation to reach what the value would be as if those events had never occurred. And this is indeed consistent with Article 10(2) of the BIT, which states that compensation for lawful expropriation should, I quote, not reflect any change in value occurring because the intended expropriation had become known earlier. Now, the question is, how do you do that? How do you exclude that knowledge from the value? This brings me back to the valuation approaches. Depending on the valuation approach, the exercise prescribed by Article 10(2) of the BIT becomes more or less straightforward, as one has to cancel out the changes in value before the valuation date occurring because the intended breach became known. Now, let's start with the DCF approach, which is a forward-looking approach, and it relies on assumptions on future cash flows. Now, it's very easy to model input parameters without the breach to create a but-for scenario that wipes out not only the breach itself, but also all the impact of the measures preceding the breaches on the value of the company or asset. The problem in our case is that the S&P Gold project was an advanced exploration project, but not advanced enough that it would be appropriate to adopt an income or DCF method, according to the prevailing mining valuation standards. Which leads me to the next valuation approach, the cost approach, which is also consistent with Article 10(2) of the BIT. It is backward-looking because it is based on historical costs. As such, it is based on the incremental value created by the expenditures on the project. As we have seen, these historical costs can be adjusted either by a PM in the multiples of exploration expenditures method, or by including financing costs such as Tanzanian bonds or Canadian Prime +2, plus a premium to have the asset available immediately, rather than having to rebuild it from scratch, as we have discussed this morning with Mr. Mwangakala. We have seen this morning with Mr. Mwangakala that any of the expropriation dates, 2018 or 2019, would have been at the beginning of a new commodity cycle. So it would have made sense to include a premium over normal financing costs, whether they are Prime +2 or Tanzanian bonds. But most importantly, the cost method is not impacted by the Tanzanian actions and measures preceding the breach itself, whether that's summer 2017, January 2018, or December 2019. Now, that brings me to the market approach. The problem with...
Can I just ask you a question?
Sure.
You refer to Article 10. I think we agree that Article 10 is about lawful expropriation.
Yes.
And so you just consider that by analogy you can apply it to illegal expropriation?
Correct.
Okay.
Because with unlawful expropriation, the amounts owed or the compensation owed would never be less than for lawful expropriation.
I understand that, yeah.
Now, that brings me to the market approach in the context of Article 10(2) of the BIT. Now, cancelling out the change in value before the valuation date occurring because the intended breach became known is inherently difficult, if not impossible, when looking at comparable transactions assets or share prices in Tanzania. All of them would be affected by the measures, and they would have been affected considerably well before summer 2017. Let me explain. The market cap approach would be based on the price of Helios shares or Shanta shares, as we have discussed this morning. And the price of shares is highly sensitive to public statements by Tanzanian officials and the actions they pursued, particularly against Barrick. This morning I've taken Mr. Wangakala to a number of examples that show that the first step of the expropriation, the amending legislation, was actually preceded by a number of statements and measures which affected investors' confidence and signaled the Tanzanians' intentions to interfere with mineral rights held by foreign investors in Tanzania. You will vividly remember how the measures against the mining industry have affected the share price of not only Barrick and Acacia, but more importantly Shanta and any other mining company operating in Tanzania. Speaking in the words of the famous Colombian novelist Gabriel Garcia Marquez, it was a chronicle of an announced death.
Can I just ask, if I understand your reasoning, you're equating statements, public statements by the president with the fact that the intended expropriation had become known earlier. So you're saying the statements are announcement of death. Is that what you're saying?
Yes, Madam President.
Because these statements could mean many different things, not necessarily expropriation.
Well, the measures in summer 2017 did not come out of the blue. The market was very well aware of the resource nationalist agenda of Professor Magufuli and his government. Now, we have seen that from, and I can take you through them again in detail, but I don't think I would do it in the interest of time. But since essentially early 2016, the resource nationalist agenda has tainted the investors' perception of Tanzania as an investment destination, but also the share prices of those companies, those mining companies operating in Tanzania, like Acacia, Barrick, and most importantly, Shanta, quite dramatically. So the fact that the amending legislation in 2017 was only enacted in summer 2017 should not detract from the fact that it took months, if not years, before that where investors and essentially the markets became aware of what was going to happen. Did they know the exact extent of the measures? No, they didn't. But they knew that Tanzania was going down a resource nationalist route that then culminated in the 2017 amending legislation, the 2018 retention license cancellation, and then the tender in December 2019. It wasn't a surprise.
No, I understand that. Just go on.
Dr. Voigt, is it your case then that the valuation has to ignore events that caused the market to become worried that what eventually happened might happen?
Yes, correct. And that's prescribed by Article 10.2 of the BIT.
Even though 10.2 says the expropriation had become known, you're not saying it has to be known. You're saying it's enough for it to be suspected that it is going to happen.
Well, it is enough to be suspected, and coming back to the valuation exercise. Now, we have agreed that we have in principle, three valuation approaches. Now, two of those approaches are less susceptible to being affected by the upcoming legislation. Now, we have been talking a lot about the market approach this morning. also yesterday. And what I'm saying is that if we pick the market approach and a very specific sort of variant of the market approach where we are essentially looking at comparable transactions in Tanzania or comparable transactions involving companies in Tanzania or doing or active in the mining industry in Tanzania, this valuation method becomes extremely sensitive to expectations in the market that were formed by the resource nationalist agenda of Professor Magufuli. And indeed, it would, if we were to use a market approach and essentially ignore the investors' expectations that were expecting something to happen in the context of that resource nationalist agenda, it would be essentially rewarding Tanzania for making these making the resource nationalist agenda public, which culminated then in the amending legislation.
You could imagine a policy about national resources that would produce a change in legislation that is not a treaty breach in a sense that it would respect acquired rights or something like that. And so that is why I have a little, I understand your explanation, and I can certainly see that asset-based valuation is less sensitive to the environment than a market approach. But I mean, the expropriation had become known earlier to me as 1 week before the decree somehow is leaked. And that is not the type of situation we have here.
Madam President, if I may, that's not the situation we have here. This wasn't a situation where there was a solemn, sober announcement that there would be a review of the mineral resources sector. No, this was effectively a post-electoral ploy which involved brash statements made at public rallies used to whip up public sentiment against foreign mining companies. There was no transparency across this review process. We even heard from Professor Nkrumah, the closest thing they had to a review process was an investigating committee that dealt only with the concentrates that were being exported by copper and gold producers. So to equate this to a situation where there is an orderly process for the review of contracts, which happens all across Africa and other parts of the developing world, and the foreign interests are brought in as stakeholders in that process, would be a false equivalency. This was a situation where the entire market was tainted by public statements, actions, statements that foreign mining companies just called themselves investors but were in fact thieves. Everyone could read the tea leaves here, including the investors. I'll pass now back to the person who knows how to do math.
And indeed, when valuing the asset, I think the fundamental premise behind it should be that government rhetoric or political rhetoric as such before, during, or after the expropriation shouldn't change the value of the asset. That value should be untainted by political rhetoric. Now, you can either try to use the market method or market approach and adjust it accordingly, which I'm going to take you through in a minute, or the much easier approach is to take a method which is actually not susceptible to rhetoric and sort of the announcements of the resource nationalist agenda. So now, to obtain a value based on market capitalization or a share price in this environment in Tanzania would require, as I said, a number of actually very subjective adjustments. There is almost no chance that such an adjusted result would actually be a reasonable proxy for Winshear's or Shanta's share value and the fair market price of the asset at the time. But I don't want to dodge the question that Judge Johnson had this morning, and I think also yesterday, when you asked Mr. Mangakala how to adjust the Shanta transaction to exclude the measures by Tanzania. Now, I've said I think it's a highly speculative exercise, but I will try to help you to get there. Now, as you've heard yesterday, Ms. Wall has already carried out an illustration of how you might adjust the Shanta share price to reach a methodologically coherent valuation of the project at the potential valuation dates. First, it would require an adjustment of the starting point, the Shanta share price, to estimate what the fair market value would have been at that date had Helio been a willing seller and Shanta a non-synergistic willing buyer. I think in her second report, Ms. Wall considers one way of doing this would be to use the Helio and Shanta respective resource multiples, hence the US dollar per resource ounce of gold that they had at the time. Now, in adjusting the starting position, one would also have to disregard the impact of Tanzania's actions and measures in the lead up to 2017 that had already affected the share price, as I've said before. Now, in order to adjust the Shanta share price to negate those actions, one would have to go back further in time, actually quite a long way before June 2017, perhaps 2015 when President Magufuli was elected or shortly thereafter. I note that obviously the further back we go, the further we take ourselves away from the valuation date and the more speculative the whole exercise becomes. Now finally, you would also need to adjust the Shanta share price upwards to reflect the fact that the Shanta transaction contemplated was not shareholders receiving cash, but rather a stake in the merged Shanta Helio entity. You therefore need to adjust the Shanta share price upwards to reflect the estimated value of Helio's shares in that merged entity. And one way of doing this would be, again, to use the Shanta resource multiple of $59 per ounce and add Helio's resources to Shanta's market cap at that price. Now, Ms. Wall did it in her first report and uplifted the Shanta share price by approximately 5 to 9 times on that basis. Now, once you have adjusted that Shanta share price to reflect the fair market value of the project at the transaction date, you then need to adjust it forward to the valuation date that you choose. It's inevitably a very difficult exercise, especially when you have to exclude the respondent's actions during that time. Now, Judge Johnson, you have asked Mr. Mangakala today why using the gold price index or gold price would be a good starting point. Our position is that it would not be a good starting point. You can use it. It's better than just the Shanta share price, but it doesn't capture the whole environment. Why? The gold price indeed correlates to the share price of a gold exploration company or any gold mining company. However, the share price of such a company does not track the gold price on a one-to-one basis. Rather, share prices would be expected to move by a factor of the gold price. There's always a lever between the gold price and the price of a gold mining company or gold exploration company. For example, the gold price might not only affect sales, but also other aspects of the business, such as volume of production, ability to attract financing, and others. It is therefore our position that the ARCA index would be more appropriate should the tribunal wish to conduct such an exercise. Now, Ms. Wall did that exercise at section 4 of her second report, and the result was an implied fair market value between 72 and 129 million Canadian dollars. That's obviously much more consistent with Ms. Wall's primary valuation approach, not Mr. Mangakala's $5 million valuation, but as I say, to be honest, it is essentially guesswork. This is why we think, and as Ms. Wall has explained in her first and second report, the cost approach is the best valuation approach available in this case under all the circumstances considered. And now I hand over to my colleague, Mr. Barrier, who will discuss the prospecting license issue.
Yes, I would simply like to circle back to Judge Johnson's question on day one, which seems so long ago already, but about what was expropriated exactly. I want to do this because there has been some back and forth relating to the 9 prospecting licenses that surround the project area, that are the fringes of the project area and surround the retention licenses. And I would like to expand on this issue just to make clear that, to make the claimant's position on this point clear. So the claimant's position is that by expropriating the 4 retention licenses, Tanzania expropriated the entirety of the SMP Gold project. So just to explain, so both a factual and a legal issue. But from a factual perspective, I will refer you back to Mr. Williams' testimony. This is on day 2, page 314 and 315. And he explained that the 9 prospecting licenses are not standalone areas that have their own deposits that can be explored and mined separately. They were part of a global project area. And he explained that the exploration method employed by the claimant, and here in this case in BTL, was to explore this entire global project area to identify the main targets of interest, which are then prioritized and selected for more advanced exploration. And this is what happened with the licenses that ultimately became the retention licenses, all of which contained targets of interest and for which the claimant established mineral resource estimates with the assistance of various consultants. These licenses, the 4 retention licenses, form the core of the project in this sense. And it is on these licenses areas that the mine would have been constructed. The other licenses, so the surrounding 9 prospecting licenses, remained available for potential extension of the mine as a potential resource for the future. But I think it's probably important to visualize what the project looked like initially at the first stage of exploration. And you have this map on the screen. It comes from Exhibit C29 at page 4. And it is particularly interesting because, as you can see, this is the result of the initial exploration. So only rock sampling over the whole project area, as I discussed earlier. And you can see all these gold intrusions that follow essentially the Saza shear zone that you see here. And this is, so this is the main targets that were prioritized by the claimant eventually. And bear in mind this L shape of the project. So it had satellite potential deposits, but the important thing is this strike across the shear zone. So over the years, the claimant's efforts have been geared towards maintaining this initial project area. And you have to recall that on each renewal of a prospecting license, BTL had to relinquish 50% of this prospecting license. And this is why the number of licenses increases over time. And you start from these 4 licenses to and end up with 4 retention licenses and 9 prospecting licenses. And it's probably clearer from the map of the project on Exhibit C241, which is the situation in 2015. And you see here, essentially, these 4 retention licenses in the middle, that kind of follow this.
So
the
can you just, just tell us which one are the retention license? Oh, here it says
They say-
retention.
yes,
Yeah,
it's
yeah,
those
that's
that
fine. So
indicate
it's
are.
Ilunga, Gap,
That's Saza,
Saza-
Ilunga, Gap, and Quarry.
Quarry, yes. Yeah, fine.
Thanks. Right, so Saza,
Yeah,
Ilunga,
yeah, it's clear.
Gap, and Quarry. And actually, I would like to compare this map with the next one we have, which is from Exhibit C129 at page 25. And bear in mind the shape of the retention licenses. This map we will see is from the CCIC mineral resource estimate. And this shows the various deposits, and in particular you see the gray areas. Those are the location of the mineral resource of the project. And as you can see, they strike along the Saza shear zone, and they are located on the areas of the retention licenses. This is what I said, this is the core of the project. This is where the mineral resource is defined. This is where the mine would be eventually constructed.
And we could, of course, check this by looking into the reports, but were there no deposits identified in non-retention license areas?
There were deposits identified, but no mineral resource defined. So there were satellite potential deposits that were resulted from the initial exploration, but the most prospective deposits were those that were eventually covered by the retention license areas. So you have Kenge,
Yeah,
Mbenge.
and Porcupine. Yeah.
Kenge, Mbenge, and Porcupine in the east. So
Yeah.
essentially the big gray area here at Razorback is the Kenge and Mbenge deposits. And of course there are additional deposits around which were discovered as part of the initial exploration efforts. But as I explained earlier, the Helio and BTL focused on the most promising targets which were at the center of the project and kept the other deposits for future development in case, well, for after the mine would be developed, essentially. And maybe we can look at the SRK mine plan for these areas. It's at Exhibit C100. It's on page C, and on page 136. Sorry. So here again, we would have to bear in mind the shape of the project, the L shape of the project. Lost it. It's the L shape of the project. You have the Mbenge and Kenge deposit and the Porcupine deposit, and this is how SRK envisaged it would be mined eventually. So this is the basis on which the project would be developed and possibly then extended to the adjacent areas. Now, where does that take us from a legal perspective? So what happened when Tanzania expropriated the 4 retention licenses? Essentially, after what I showed you, it took the most valuable part of the project because it's the part of the project where resource was defined and where the mines were supposed to be. And that, in doing so, it also expropriated the project in its entirety. Why? It's because simply, although BTL was still holding these prospecting licenses, there was nothing it could do with them because they were at a low-level exploration. They had only been through the initial steps of exploration. There were deposits that had been identified, but it was still very rough. The sole purpose of these adjacent licenses was to host potential extensions of the future mine. Carving out, like you can see from the previous maps, but carving out the retention license area basically creates a hole in the middle of the project. But essentially, and more importantly, after what happened, no investor would have been interested in investing in satellite deposits that have not been defined as a resource anymore. And no investor in their right mind would invest in the project that has been already partly expropriated by the state. Without the retention licenses, the prospecting license essentially lost the entirety of their value. And so did BTL various tangible and intangible assets associated with the project. So here we're talking about base camp, the materials relating to the exploration that were left on site, the core and geological data, the field office, but also the prospecting licenses themselves. They lost all value they could have had before when they were associated with the retention license areas. And in the same vein, BTL's shares also lost the value they could have had because BTL was the owner, well, not the owner, but the
holder.
recipient of the retention licenses. So in other words, like looking at this from the perspective of Article 10.5 of the BIT, Tanzania directly expropriated the 4 retention license areas, retention license, through the 2017 legislation, the 2018 regulations, and in our case, the invitation to tender. So in that sense, the retention licenses were, quote, nationalized or otherwise directly expropriated through formal transfer of title or outright seizure. But Tanzania also indirectly expropriated all of the claimants' assets that had value only because of the resources held under the retention licenses. The indirect expropriation here, and I quote from Article 10.5 of the BIT, results from a measure or a series of measures of a party that have an effect equivalent to direct expropriation without formal transfer of title or outright seizure. And indeed, the expropriation of the retention licenses had an effect equivalent to expropriation on the rest of the project because it deprived it of its value. And even though Tanzania did not seize the assets in question, these assets remained valueless.
So you're saying, if I can summarize it, that the direct expropriation of the retention licenses somehow caused the indirect expropriation of the other areas, the PL areas.
It's not cause.
It's not a causation?
No, it's...
No, because the thing I was looking to find is where is the causation between the cancellation of the retention licenses and the damage to the whole project. But you're not putting this as a causation point. You're posing it now as direct expropriation for the retention licenses and indirect expropriation for the prospecting licenses. Is this the correct summary?
Yes, but that would be concurrent at the same time. But one point I would like to add to this, sorry, before Judge Johnson asks his question, is that like the value that was expropriated was really in the retention licenses. This is where the mineral resource was, and these were the value, the actual assets of the company. All the other assets, including the prospecting licenses, were only a fraction of the overall project value. So essentially, the rest of the project was expropriated at the same time indirectly. But really, if you focus on it, it's the core of the project consisting of the retention licenses that constitute the larger part of the value of the overall project.
So you're saying it happens at the same time?
Yes.
Let me try.
And what is the time? No, because I understood that the expropriation was in 3 steps.
Yes.
So the direct taking, can the direct taking be in 3 steps?
The direct taking would be the 2018 regulations.
Yeah.
Mr. Varier, I want to try to restate what I've heard you say, and you tell me if I'm wrong. What I'm hearing is the retention licenses were expropriated, as you say, and a result of that expropriation of the retention licenses was to leave the remaining prospecting licenses valueless. That is, without the retention license areas, those prospecting licenses would have they would have no value. You couldn't sell them to anybody. Is that
No.
right? That's not what you're
That's not
saying?
what I said.
What are you saying? Because certainly the state, those licenses continued to exist.
No, apologies.
Sorry.
Yeah, sorry, it's the term results that bothered me. It's not some kind of cascade of expropriation. The whole thing happened at the same time. And actually, if you want to rationalize it, you can do it either way. It can be with or without indirect expropriation, because the direct expropriation of the retention licenses expropriates the value of the entire project, really.
We had interrupted you. I'm not sure. Were you done with your presentation?
I was, yes.
Yeah,
Thank
good.
you, Madam President.
And you were,
And that concludes
That concludes
our
the-
responses to your questions.
good, thank you. Should we take about 10 minutes and then we'll listen to the respondents? Is that fine? Good. Let's start again at 15 past. Then.
Yes,
Now is the
yes, we are ready.
right time?
No, we are ready.
Good.
Yes.
Fine. So we're ready and happy to listen.
Thank you, Madam President. The respondent, before addressing the questions that were raised by the tribunal to the parties yesterday, we just wanted to comment on the presentation made by our learned defense. It was our understanding that the tribunal had directed our parties to respond to 4 issues. The first one was specific to the respondent. The second and the third was to the claimants. And both parties were also required to address the issue of FET, minimum standard on treatment in accordance with international law. So that was our understanding initially, but our colleagues have gone to the extent of presenting some issues which are outside this scope. So that's the comment that we wanted to make. But that does not mean that we are not commenting on the issues that have been presented to us. So,
Can I just say something? There may have been a misunderstanding, because as long as you don't take more than an hour, you can add other submissions in addition to the answers to the questions. But in any event, since if this was the last opportunity, it would be an issue. Since there are written submissions afterwards, you can still add whatever you wish at that point.
thank you very, very much, Madam President. That was our understanding, and we really thank you for the clarification that some of the issues we'll be able to address them in the post-hearing brief. Perfect. Now, The issue of jurisdiction, which will also be very, very brief on the side of the respondent, is that the respondent made submissions on the issue of jurisdiction in several paragraphs, in both the counter memorial and in the rejoinder. So I'll just give you an example. For example, in the counter memorial, paragraphs 337, 339, 429, they make reference to the issue of jurisdiction. But also, if you go to the rejoinder, you'll also see paragraphs 9, 198, 199, paragraph 2, 204, and paragraph 207. So the question that was put to the respondent by the tribunal was that this, among the reliefs claimed by the respondent, the issue of jurisdiction was not part, and the question was whether or not we want it to be included in the reliefs that we are claiming. So the answer is yes. It should form part of the prayers of the respondent.
The prayer would be requests that the tribunal denies jurisdiction over the dispute.
Yes.
That is what you mean, for the reasons that are explained in the text of the memorials.
Yes, Madam President. Now, on the second issue about the guarantees provided for in the BIT regarding FET and the minimum standards in accordance with international law, it is the respondent's submission that given the time constraint, we did not have sufficient time to make submission on this issue, which we consider an important issue in these proceedings, and it relates to certain established legal principles. So we pray that we be given the opportunity to address your honorable tribunal when we make our post-hearing brief. By then, we will have had enough time to consult authorities in this area and the jurisprudence so that we have a comprehensive response on this aspect. Madam President, apart from these questions, we had one issue which was also reserved for the respondent to comment on, and this relates to an assertion made on the second day, on the 14th February 2013, at the end of day 2 hearing session. The tribunal directed the respondent to comment on the issue posed by the counsel for the claimant in relation to concerns raised by the respondent in relation to due process during the hearing of the claimant's witnesses. That direction resulted from the respondent's assertion during cross-examination session that it was noted that some interference made by the tribunal to the respondent's counsel during that day. If specific reference is made to transcript day 2, page 586, line 18 to line 22. Now, the claimant at the end of this day 2 session commented that both parties were equally provided time, and the respondent had used its time in the way it deemed appropriate as per section 18.14(5) of Procedural Order 1. The tribunal could ask questions at any time which do not count against the party's time allocation. Madam President, we wish to make it clear that the respondent is aware of Procedural Order 5, particularly Section E, paragraph 18 to 21, concerning the time allocation, that the tribunal's questions do not count against parties' time allocation, and that the tribunal never counted against parties' time. The Secretary of the Tribunal was kind enough to forward the time allocation for both parties. However, our main concern arises on the fact that at the commencement of day 2 hearing, the tribunal indicated clearly as an introduction on the procedure of hearing that the President highlighted to the parties that the claimant counsel will start with introductory questions, then the respondent counsel will proceed with the cross-examination, and the tribunal will ask its questions at the end of questioning. Quoting from the transcript day 2, page 263, line 6 to 12, I quote, "The tribunal will probably ask its questions rather at the end, because experience shows that if you wait, the answer comes in any event." It is also noted that the tribunal once in a while may ask for clarifications as we go along. Madam President, the respondent acknowledged that this approach is normal and acceptable procedure of conducting international proceedings of this nature. However, the respondent concern is that when the witness was cross-examined by the respondent, the tribunal would, instead of leaving the witness to provide an answer to the finality, then the tribunal would assist the witness to reply the questions posed to the witness. It was the observation of the respondent that the interference of the tribunal made the witness more guided with the answer, and thus making the respondent very uncomfortable in the proceedings of that day. As the questions were directed to the witness, practice dictates that the witness ought to have answered the question, and if the question was not clear to the witness, then the counsel for the respondent would have been asked to rephrase the question, but not for the tribunal or counsel for the claimant. For example, the first example is the witness in page 338 of the transcript, from line 15 to 25, was asked a question. I quote, "We will get to that, but I'm saying, did you sign an agreement without getting your shareholders' approval. Is that what you are saying? From this question, it was expected that the witness would answer yes or no, or I don't know, in the case that the witness did not know the answer, to ask for the same question to be rephrased. However, the tribunal answered the question and ended up with a concluding remark. I quote, "I think, just to simplify this, I understand that it was signed under the condition that shareholders and stock exchange would approve. And Mr. Williams, if I misunderstood you, in this context, it seems that the tribunal differed from the respondent line of questioning. Again, the tribunal interfered and asked a straight leading question that were basically giving an indication of the answer. For example, I quote, "Can I just ask for clarification and then give the floor back, of course, and you will excuse the interruption. The 25 million US dollars that are mentioned here are supposed to equate approximately Canadian dollars 33 that you mentioned before. This is 2018, so it is not 2019. That may make a difference, but in terms of the concept, is it that what it is, meaning that does not include additional costs such as overheads and raising investments and the like, correct?" The witness responded, "Correct." So, Madam President, that's just an example. Now, the respondent raised an issue and sought guidance from the tribunal on the appropriateness or otherwise of such interference. The reason why, as I've indicated, troubled the respondent's counsel was that the question are asked by the respondent, and the respondent would want an answer to that question so that to use those answers in arguing the case. So that is the reason why this was raised. There were other examples, but in the interest of time. So this was raised. So our comment on this is that as a matter of principle of hearing cases of international nature, like this one, in international arbitration, the most essential element of international arbitration is impartiality, independence, and neutrality. The tribunal has a duty to show to the parties that both parties are afforded an opportunity to prosecute their case in the way they deem fit and appropriate. The tribunal's duty to interfere is when a question that is asked is unfair, is prejudicial, or is demeaning to the witness, or if the question is not clear to the witness, the counsel in question will be asked to clarify the question. That was the understanding by the respondent. So in these proceedings, our understanding was that it will follow that line of examination as a practice, and that's why we had raised a concern about that. Now, Being a revisited procedural order 1, the aspect of power of the tribunal's control over proceedings of hearing witness, the respondent is of the view that the tribunal should not only implement its obligation imposed to it by the parties through the procedural order. Further to that, the respondent is happy to be guided and receive directives from the tribunal rather than being interfered as evidenced above. But finally, at the closure of the proceedings, the President made a comment which I quote, "Absolutely, you will certainly have an opportunity to say so. I would just like to say that when I chair, I usually take the liberty of interrupting. It has nothing to do with the counsel, who the counsel is. When I have a feeling that the witness does not understand the question and I can help to make things easier, that is the only purpose of intervening." And I'm just saying this so that there is no misunderstanding of any sort about interventions. That is the only reason for doing it. So, Madam President, rather we received this comment at a very late stage of the hearing, while we had already raised our concern. We understand, I repeat again, the tribunal's role to control the proceedings, but our comment was based on that we be given an opportunity to ask a question, and the question is responded to by the witness, because that will be the question of the counsel for the respondent, not the question of the tribunal. So, Madam President, having said so, this brings me to the end on the issues that the respondent wanted to raise with this tribunal. Thank you very much.
Thank you. We have taken note of your comments. I can only repeat that the only purpose of the, what you call interference, but it was rather a way of facilitating the witness examination. I'm sorry if it was misunderstood, and the only thing I can say is this tribunal is very much aware of its duty of impartiality and independence, and it does comply with it, and it will comply with it. And I trust this will give some comfort to the respondents.
Yes, it does.
Good. Should we take another short break, and then we will reconvene for procedural discussions about the course of the finalization of the arbitration? Or is there anything the parties would like to add?
Madam President, we're happy to crack on.
Sorry?
We're happy to crack on. We're all adequately caffeinated, and we're happy to continue.
And do the respondents not want a break?
Madam President, it has been a long hearing, and I think we can proceed.
Okay, good.
Okay,
I thought that was, the fact that it was long was rather called for a break, but that it's the reverse, so that's fine. The tribunal had a few had views about the next steps. The first one, some are already set, right, and others are set but need to be discussed now. We had provided in procedural order number 5 that the tribunal would determine a date for uploading the audio-video recording of the proceedings on the website. We thought that we would do this next week, if that is fine with everyone.
Yes, Madam President.
Yes, Madam President.
Good. Then the next one, another step is the transcript corrections. You will have the final transcript by tonight. You can go through it and see whether there are mistakes that you will, I apologize to the court reporters whether that's what it is, whether there are any mistakes that you wish to correct. Then the best situation would be for counsel to agree on corrections, and if there are corrections that are being requested and are not agreed, then you would tell the tribunal. We had said in procedural order number 1 that this would be 2 weeks after the close of the hearing, which brings us to the 2nd of March. Is that fine?
It is for the claimant.
It is good. 2nd of March. Then the next item on my list is post-hearing briefs. We had mentioned them in PO1 and PO5. I'll make the tribunal's suggestions, and then you can comment. In terms of content, the idea is not to repeat what you have written in your earlier written submissions, but rather to comment on the evidence that we heard this week and put it back into the context of your case. Obviously, you can also add answers to the questions or comments on your opponent's presentations today. That's essentially the content of the post-hearing briefs. We had in mind simultaneous post-hearing briefs. Now, it is true that sometimes parties wish to have a second round if in case there are points that they wish to address that the other side raised in the post-hearing brief. We'll listen what you have in mind. For the first post-hearing brief, or the only post-hearing brief, depending on how we deal with that, we would imagine a time period like 6 weeks, but obviously you can comment on that. We had also discussed whether we should set page limits. We had in mind something like 60 pages, but that also is a proposal, of course. No new factual evidence. If there is new legal authorities that you wish to provide, maybe in respect of the question of minimum standards of treatment, maybe there's one or the other case that you would wish to add, you may do so, but I would really be limited to legal authorities and no new exhibits. Yes, I should add that the tribunal has in mind to deliberate tomorrow, and in a first exchange of views, and then we would redeliberate after we have heard you, we have received your post-hearing briefs. It could be that tomorrow, when we have in our discussions one or the other issue comes up that we have not asked yesterday and that we think is important. At this stage, we don't think so, but sometimes it happens that when you have these discussions, other issues come up. If that is the case, then we would write to you, and this could then be covered in the post-hearing briefs. Let me just go through the different steps, and then you can comment on all of it. We would also provide for cost statements sometime after the post-hearing briefs. In the tribunal's view, this could just be an itemization of your costs per category without actual submissions. But if there is something important to be said about costs, that would then be the time as well. And I think that, let me look at my co-arbitrators. Did I cover the ground? Yes. So that is what the tribunal had in terms of proposals for the parties' comments. If you wish to briefly discuss within your teams, of course, you're welcome. If you want to react right away, you can do so as well.
Madam President, you might have gleaned that this isn't the first time that we've been to the square dance with our friends across from us, and I'm confident that we'll reach agreement on the terms, in particular with respect to page limits. Everything that the tribunal has mapped out so far is completely aligned with how we would approach the situation, save maybe the page limit. Given the block quoting that often occurs from transcripts, it might be that we want to agree with the input of our friends that the page limit is increased, but nothing more than 100 pages, I should think.
Fine. How does it look like on the respondent's side? If you want a short break
please.
to discuss it with your colleagues, you're welcome.
Just a minute.
Sure.
Just a minute.
Sure.
Madam President, so after having a short discussion with my colleagues here, we propose that we be given just a short adjournment so that we confer with our colleagues on the other side. And then that's what we have been doing, at least in the previous case. So just a short time, then we should be able to bring what we have agreed between the parties.
You want to do this now? Yeah, that's
Yes.
perfect. Yeah, sure.
Yes.
So we'll just be available, and whenever you're ready, you can get us in
Sure,
the breakout room?
sure.
Yeah, good.
Yes, yes.
So we're ready to listen.
Thank you, Madam President. The parties' agreement is to have both the PHB and the submission of costs on the same date by simultaneous exchange on the 3rd of May with a page limit of 100 pages. And then a simultaneous exchange of schedules of costs, so a short submission, on the 17th of May. And I will let my friends confirm that this reflects our agreement.
That was 17th of May.
Yes.
Would you wish to confirm, add anything?
Yes, we have agreed, and we confirm that this is what parties have agreed.
Good. So that's perfect. So let me just restate, 3rd of May, post-hearing brief with cost submissions, 100 pages maximum. And then on the 17th of May, cost statements or schedules. That's just an itemization of the costs by category without supporting documentation unless anyone asks for it, but I don't think it should be needed.
This is your understanding, Madam President.
Good. Then I think, is there any, maybe I should say what then happens thereafter. As I mentioned, the tribunal will have an initial exchange of views, but it will then, of course, deliberate on the basis of your post-hearing briefs thereafter. It knows that there is criticism about the time that investment awards do take to be issued. So being aware of it, it will do its best to be diligent and get to a conclusion within the reasonable time. At the same time, it is true that there's a lot to be considered, and we need to do this carefully. So it is difficult for us to give you now an approximate date when we could finalize the award. I would say that around 3 months, 4 months after your post-hearing briefs, we will tell you where we stand in terms of progress towards the award. Is there anything else that the parties would like to add at this stage? Any complaint, comment, question?
It only remains for the claimant side to thank the tribunal, Mr. Langer, obviously Ms. Rosenberg, Mr. Kasdan, and our friends for the efficient conduct of these proceedings.
Thank you.
Thank you.
Anything on the respondent side?
Madam President, nothing but just to extend some gratitude on behalf of the respondent, the United Republic of Tanzania, for all the parties who participated in these proceedings. Everyone, starting from you, Madam President, and the honorable members, but also the Secretariat, specifically Madam Ella Rosenberg and the team, but also we wish to thank our learned brothers, the counsel for the claimant, for the manner in which we conducted these proceedings. But we also wish to extend our gratitude to our little-time stenographer, David Kasdan, also has done a great work. Otherwise, the respondent is thankful, and in Swahili we say asante, that meaning thank you.
Asante sana.
So it remains for the tribunal to now thank you. We would like to thank the court reporter, of course, the secretary for perfect organization. We would like to thank all the party representatives who spent many hours here very patiently listening. We would, of course, also thank counsel for very efficient conduct of the hearing, but also for a very efficient conduct of the pre-hearing written submission phase. We did appreciate, also appreciated the cooperation during this hearing. We had some adjustment difficulties, but I think we resolved them as we went along through the days, and I'm very pleased that we can close this hearing now, and I wish everybody a safe travel home and well-deserved rest.
Yeah.
Goodbye to everyone.
Yeah, yeah.